We will start our session with a very quick review for what did we explain day before yesterday in the last session. Okay. Can you see my screen now?
Yes, sir, we can see your screen.
Okay, excellent. Day before yesterday, we spoke about the privacy and what does privacy mean. And we mentioned that the privacy, it will be personal right to exchange his personal information to specific persons or entity or organizations and give them the right to use this information or not use it. And we mentioned that the privacy, it's we consider it as talk of the town now, although a lot of countries were speaking about privacy, maybe as in USA. In 1974, we had the first law, and for European Union, we had the law for maybe 1995. But now the privacy, it came to the picture again, and it's a very important topic, and a lot of people there spoke about it. They are speaking about it right now because, as we mentioned, there are a lot of sites which are working on collecting the information for the people to send them their offers, services, and we are processing this information. And as we experienced before, that there are some sites that are selling this information and doing business and doing money by selling your personal information to other organizations. Sometimes you receive some emails from companies which you don't know about them, but you will know that there is a relationship between these companies and maybe other companies which you were in contact with them. Also, the GDPR, it came to the picture and it make the personal information and privacy a very important issue, because if the organization violates the the law, this means that it will be subject for fines. It can reach up to 2 million or 4 million euro. Then we spoke about some other concepts for the privacy, and we said that the GDPR, the law, it's related to European Union citizen, and it protects their data, and it has guidelines. And these guidelines for the organizations, how to protect the collected data, and guidelines for collecting the information and how to store it, how to protect it. Also, it has guidelines for data subjects, and these data subjects, what are the rights and how we can allow the organization to use their personal data or to remove their personal data from these organizations and keep this data private for them. Also, we had some other definitions for the GDPR. The most important definitions as the data controller, we have the data processor, we have the data subject, and we mentioned that the data controller, it is a person who will collect the data, and he will be responsible for protecting the data and mention what are the activities it will be processed on this data. The data processor, it will be the entity or the person which it will process the data on behalf of the controller. Of course, there must be a contract or agreement between the controller and the processor. Finally, the data subject is the person who owns the personal information, and it's the natural person which provides his information to the organization or for the data controller. And we went through all this information day before yesterday. Do you have any questions regarding last session before starting today's session? Okay. Now let's start our session for the GDPR foundation course. We had in the GDPR and the concepts of GDPR some perceptions, and unfortunately they are wrong perceptions. Like what? That GDPR is only applicable in European Union. Do you agree about this concept or this principle? What is your opinion? Do you agree about this principle that GDPR is only applicable in European Union?
No, sir. This also for applicable for US, America.
Okay. Then GDPR, it will be applicable in any location having, processing, or storing the information for European citizens. This is very important. You have to keep it in your mind. I don't care about the location of the country, but if you have European Union citizens' personal information, and this information is shared with any other countries outside European Union, then GDPR, it will be valid. Then if I have in my company, which is reside in Saudi Arabia, some Arabian citizens' information, then GDPR, it will be valid. Then it's not valid only in European Union, it will be valid for European Union citizens, wherever these information are reside. We have another method for that. The consent is the only method of collecting and processing personal data. If you want to process personal data, the way to collect this data, it's the consent. Again, this is a wrong perception, because as we will see in the next slide, that we have 5 or 6 different methods for allowing the organizations to collect the personal data. We have 6 different methods allow the organization to collect the personal data and process this personal data. And we will come to these methods in details in the next few slides. Another perception that the GDPR is concentrating on fines. GDPR, we are not concentrating on fines. Fines, it will be last resort. Why? Because GDPR, it will give you guidelines for the organizations, how to collect the data, what are the authorized and legitimate purposes to collecting the data, and how to protect the personal data, how to store it. Then it will give guidelines for data subject to protect their data and keep the data private and to share it with the organization if they require, or they can withdraw this information if they don't want this organization to deal with their data, and so on. Then you will find that fines, it will come at the last step. GDPR, it will provide you a lot of information about collecting, processing, storing the data, and it will give also guidelines for the users for protecting their privacy. But if this information or guidelines, they are not followed in a proper way, then you are subject for the fines. Another perception that the organization requires data processing officer, DPO, all organization requires data processing officer. As you remember from our session day before yesterday, we mentioned that the data processor officer or DPO, he is the person who is responsible for managing the privacy data in the organization, and he is the person who have to make sure that he is compliant with the GDPR, and he is a contact person with the supervisory agents. And the DBO, it will be only required if you have a huge number or huge size of the personal data the organization dealing with. But if the organization, they don't have a large number of personal data, then there is no need to have a dedicated DBO. It will be enough just to have single this role to be assigned to any other existing role, maybe the legal department manager or whatever, then he will have the role of the data processing officer. And it is very important to have a data processing officer role, but it's not a dedicated person. It can be any other person who can do the exercise on his behalf. Okay, any questions?
Yeah, hi. The last point, which says all the organization requires DPO. So, is there any kind of benchmark that any company can appoint such person? Like, for example, any financial numbers, like I have this 10 lakhs, rupees or 10 lakhs kind of numbers. So beyond that, I have to have a DPO. So, is there any kind of numbers that has been decided by GDPR?
Okay, this is a good question. Unfortunately, not.
Okay.
Unfortunately, not. Then by the end of the day, it will be left for the organization. If the organization, it can handle the number of the personal records, and it's able to process it and assign this role to specific or existing role in the company, it will be okay with it. Otherwise, if the company it see that the size of the data or size of the records of the personal information, it's too much and we are not able to handle it with any existing role beside his original job, then this means that we should have a dedicated DBO.
Sir, one question. Why GDPR is concentrating on fines mostly? It should be concentrating on the protection of the asset or data.
No, we said that this is a wrong perception. GDPR, it's not concentrating on fines.
Okay, these perceptions are wrong, right?
All the perceptions which we have it in front of us on the screen are wrong. GDPR is only applicable in European Union. No, it's not. It will be applicable for the European citizens information. Then if this European citizen information, it's reside in Saudi Arabia or India or any other country, then GDPR, it will be applicable. Consent is the only method. No, it is not the only method. We have 6 different methods. GDPR in concentrating on fines. No, it's not concentrating on fines.
Okay, these statements are wrong. These are
These
wrong
statements
perceptions.
are wrong, yes. But
Okay,
these are unfortunately perceptions for the IT people in the market.
Yeah, that's why these are perceptions, right?
Yes.
Yeah.
Okay. Now we will have a new module for privacy data collection, legitimate purposes. We mentioned in the last slide that we have different methods for processing legitimate data or legitimate purposes for processing data. What are they? Method number one, the data subject has given consent to the processing of his or her personal data. It's very clear. The company, they ask me, do you agree to send you some personal information or offers to your email or whatever? Then you said yes, and you agree about this. And this is the consent which This is considered the consent, and the user he provide the consent. And as we will see later, that as the user he was able to provide this consent, again he is able to withdraw the consent. He can go to the organization and say, I am really sorry, I don't want you to process this information. You know, it is something like unsubscribe. Something like unsubscribe. If you have an email, you are receiving an email from a specific company, then you have to go and say unsubscribe, then they have to remove your information from this distribution list or mail distribution list. Then you will not receive any mails from this company anymore. Then method number one, it will be the consent. Okay. Method number two, performance of contract. Please take care. Now we are speaking about what? About data processing. About data processing. What are the legitimate purposes for data processing? Performance of a contract. Now, what is performance of a contract? Suppose that you are having a contract for any service with one of a company, whatever it is. Let's say mobile service. Let's say a mobile service. And you have a mobile service contract with a specific company. Without consent, they have the right to process your data to ensure the performance of the contract, to provide you a better services. Then this means that they will not send you any offers or whatever like that. No. This is not what we mean here. What we mean by performance of a contract, for example, where the manager for the mobile company, he will say, okay, I want you to make some analysis for the data and check who are the persons who are complaining about that the service it's disconnecting, or they don't have regular connection in their areas, and use the locations. And for example, I want to know the locations where the connection or the signal it's not strong. This means that he is utilizing your personal information. What is this type of personal information? It may be location, your address, whatever the information. Then he will be able to discover, he say, yes, we have a problem with the signal or mobile signal coverage in specific areas, and we have to work on it to improve our service for our customers. And this means that it will be performance of a contract. You have already a contract for the service, and they will utilize your data for improve the service and its performance in a specific location or specific area, or for specific persons, or whatever the legitimate person which they will work on. The compliance for the or the data processing legitimate purpose. Third type, compliance with legal obligation. If there is any legal obligation, of course, it will be by police stations, by court, by any of the authorities. The authorities, we have the permission to utilize your personal data if it's under the legal obligation. Number 4, for vital interest. For example, let me give you an example for vital interest. Now we are in the COVID-19 pandemic. Ministry of Health, it can have some analysis about the personal information of the citizens to know who are the persons which we have the what we can say, the vaccine and their locations. And we say, okay, we found that the Eastern province, we have most of them, we are covered and we had the vaccines, but in the other locations, for example, in Western or maybe in different other locations in North, they don't have the vaccines and so on. Then this is one of the vital interests. Or in other methods, another example, suppose that you are on the road and you had you found that there is an accident and there is someone he is lied in this accident. Then you can take his wallet, open his wallet, and take his identification card, and you can check his name and personal information. Then you will be able to provide him the service to call his family or whatever. Is again the one of the methods of the fatal entries. Again, we have the fifth method for processing the personal or privacy data in the public interest. In the public interest. And this, again, it's related to the authorities. As we will have some examples later, it will cover this. Purposes of the legitimate interests. Purposes of legitimate interests. Let's have a look on each one of them. The consent, as we mentioned, that the data subject has given consent to the processing of his or her personal data for one or more specific persons. As I told you, it may be that the company asks you, do you want to receive some brochures, or as I did during your registration with IT certificates, do you agree that to add your information into our distribution lists? If you said yes, then I will be able to add you, then you can receive information about our services. Performance of contract. The performance of contract, as we mentioned, that you have a contract and I want to utilize the data between the your personal data in performance of contract to improve our services and provide you better services. Compliance with legal obligations. This processing, it will be necessary for compliance with legal obligation to which the control is subject. There is a controller is subject to any legal obligation. What do we mean by that? For example, the controller who collects the data receive a request from the court for some information for his customers. In this case, of course, it's a court and it's legal obligation, and he must comply with, and he can provide the information for this court, this which we call it the legal obligation. Vital interest, this again, the example, which we have it for someone, he's in the accident, and you can open his wallet, take his information, can call his family, or you can call the ambulance and give them the information of this person. You are processing his information because you had a look on it, and you send this information to the ambulance. Again, this is for vital interest of the
interests of
Sorry?
the data subject or of an
Sorry? I really appreciate if you can mute the voice, please. The public interest, the processing, it will be necessary for performance of a task. Performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. Again, this public interest. And this as a public interest, this it may be, for example, I want to process the personal information of citizens who are living in a specific area. Then I want to know the number of children in each location. This, it will help me to understand, yes, I think we have to build a park or a small garden in specific areas where the number of children are higher than in other locations where the number of adults are higher than the children, and so on. This is considered as public, and usually it will be related to official authority. Legitimate interests, processing is necessary in purpose for legitimate interest by the controller or by third party. Whatever these legitimate interests, as fundamental rights, freedom of data subject, which require protection of personal data, in particular where the data subject is child. This means that, for example, if you have data information for children, then we have to take the acceptance from their parents. These are the types of interests or the purposes which you can collect the data. Then, as we can see, we are not only consent. It can be consent, it can be vital interest, it can be legitimate purpose, it can be performance of contract, and so on. Then GDPR, they define 6 methods for collecting and processing the data, as we mentioned before. Okay. Any questions? Do you have any questions?
No.
Okay. Now we will cover a new topic for the GDPR principles. Another topic for GDPR principles. What are the GDPR principles? We have the fairness, transparency, and lawfulness. Purpose limitation, the data minimization, data accuracy, storage limitation, and integrity and confidentiality. These are the GDPR principles. Let's have one by one. What do you mean by lawfulness, fairness, and transparency? This means that the data, the personal data is processed in lawfully and fairly and transparent manner for the data subject. This means that you have to inform the data subject, you have to be very transparent with him and tell him what is the purpose of the data processing. What is the purpose of the data processing? Also, you have this purpose, it should be legal. Of course, this person, it should be legal. And finally, the data person, he must have the freedom to accept it or to deny it. It's very important, gentlemen, to know that when you will ask for a consent, it will not affect the level of the service. For example, now I am a member in a company which is providing mobile services, as we mentioned. And this company, they came and tell me, please, we need your consent when we can send you the our new offers, our new services, and so on. These companies, we are not allowed to disturb my service at all, even if I refuse to provide them the consent. Even I refuse to provide them the consent. Then this means that I must be transparent, lawfully, fairly, and so on. Okay, the second principle, purpose limitation. My data or the personal data is collected for a specific purpose, and it should not be used for any other purpose. It should be used by the controller or the processor only for the purposes which are mentioned during collecting the private data from the data subject. Don't use it in any other purpose. Then I say it will be the same. I ask for the personal data for contract, performance of contract. Now I want to make it for sending some offers. No, this is not allowed. When you ask for my personal data, to process the personal data, it was processed only for performance of the contract. And if you want to send me some offers or services or advertisings or whatever, you have to get a new consent for this specific purpose. Don't include 2 different purposes in the same consent. This is not allowed. Data minimization. You have to collect the adequate and relevant data. Whatever any data required, you should collect. Don't collect any other data which is not required for the processing activities. Don't collect any data which is not mandatory or required for the processing activities. Accuracy. The data should be updated and it should be accurate. And you have, or the controller, they have to give the permission for user access to their data to update it. For example, I change my mobile, I change my email address, I change my physical address. Then I must have a direct access, then I will be able to change my data and keep it up to date and I give it accurate. Storage limitation. Organizations, controllers, processors, they are not allowed to keep the data forever. You collect the personal data for specific activities. Then, when these activities are completed, data should be deleted. When the processing activities are completed, data should be deleted. Finally, the integrity and confidentiality. Controllers must provide the security controls to protect the personal data. They should provide the appropriate personal controls to protect the personal data and to protect that this data leakage to any other unauthorized persons. Any questions? Any questions regarding the GDPR principles?
Usama, I have a doubt. Storage limitation, can you please repeat it? I couldn't understand that.
Sorry, I cannot hear your voice. Can you repeat the question again, please?
Yeah, storage limitation. Can you please repeat it? Like I couldn't.
The storage limitation that when you collect the personal information from a specific data subject, it was collected for specific activities or processing activities, right? Then when you complete these activities, all the processing activities are completed, then you are not allowed to keep this data stored on your site as controller or processor. This data should be deleted.
So basically, once the purpose of that data is done, then which means like you have to delete the data. Is that so?
Yes, you are right, except only in one case. If you have any regulations, as we mentioned here, if you have any regulation which it require that this data, it will be stayed for some more time. In some situation, you will find that some other standards, it will mandate that the retention period of the data, it will be 1 or 2 years, for example.
Yeah, okay.
In this case, you have to keep the data for 1 or 2 years. But of course, you must have your justification. Yeah, you say, yes, my data processing activities are completed, but based on whatever any other standard, we have to keep the data, or maybe regulation of the country itself. In a country regulation, it will say that you have to keep your data at least for 1 year, for example, then you have to keep this data for 1 year.
So this is applicable for law and regulation as well, yeah?
Yes.
Okay. Thank you.
You are most welcome. Any other questions before?
Yeah. I'm so sorry. I just wanted to
go ahead.
Go on the same question of the the storage one. Yeah. So when we say there would be the retention of a data or like storage limitation for that specific data, so does that mean we will be having the retention policy into the GDPR, or will there be any kind of retention signed or into the contract of those parties? So will there be any kind of retention policy? Was my question actually.
Okay. You will have, yes, retention policy, and you will have written retention policy, and we will cover this maybe today or tomorrow, inshallah, or day after tomorrow, I mean. I will cover this in more details.
Sure. Okay. Got it.
Thank you.
Thank you.
Any other questions? please feel free to ask your question. We are here to share our experience and to understand the topic properly.
And one more thing is like data minimization, what you have said, like retrieval of data when requested by a third party, that minimal amount of data has to be, minimal amount of data only need to be provided to the third party. Is that applicable under this?
Yes. Data minimization, this means that you should collect only the required data for the processing activities. Yani, for example, as we mentioned before, we had a company which it want to print invoices. Then what are the information you require to print the invoice? The name, if it's mobile number, address. Okay, then these are the mandatory information. Why do you ask for email address? You will not send it to me by email. You will send it by physical envelopes, physical post offices. Then this means that there is no need to collect my email address. There is no need to collect my ID number and so on. Because in some situation, okay, I want to do some specific task and I will ask for a lot of information. I will say it's a good chance to have all this information, and this it will be very helpful for me in the future. I can utilize this information. This is not legal. GDPR is saying no, you are not allowed to collect any data if are not mandatory for the purpose or the activities which you ask or the user or the data subject agree about.
Yeah. Okay. Then what would be the fine? There is only a fine difference I could see with the purpose limitation and data minimization.
There are, as we mentioned day before yesterday, we have two different types of fines. If you are violating the GDPR with a minimum effect or minimum impact, then you are subject for I think 2 million euro or 2% of total revenue of last year. And if the data breach with a large or huge impact, it will be 4 million euro with, sorry, it will be 2 million euro with 4% or 4% of the last revenue, which is bigger.
Yeah. So the purpose limitation, like what you mentioned in the second one, and the data minimization, what you have mentioned in third part. So purpose limitation is also like you collect the data for the specific purpose, and that needs to be explicitly specified, and it should have a legitimate purpose.
Yes.
So in data minimization also, it is like you need to collect and process only the required information for that particular task.
That's fine. That's fine.
So these two have a very small fine line between them. It looks
not small. The purpose, it is the activity itself. It is the activity. I want to print the invoice. Data minimization, it will be the information which you have to collect to do the purpose.
Oh, okay. Yeah, yeah. I got it now. Thank you. Thank you. Yeah.
You're almost right. Okay, great. Now we will go a very interesting point, and I'm quite sure that most of us see this privacy notice, but he did not concentrate on. Let's have a look. What is a privacy notice? This privacy notice, it's a public document. This is very important, public document. This means that it should be shared in public for all the users from an organization that explains how the organization processes personal data, how we will process personal data, and how it applies data protection principles. Then now I am a company and I want to collect the data. Then I want to explain to my customers why do I need to collect their privacy information and how do I protect this information. What are the activities or the processing activities, and what are the data which it will be collected, and how this data it will be collected. This must be very clear in the privacy notes. What is the objectives of the privacy notes? Number one, the organization must provide people with privacy notes. What it will do? This, it will provide concise, transparent, intangible, and easy acceptable form. This, it should be very easy form which you can reach for it very easy. The objective that you can reach to this document very easy. And I will show it to you now when we go to the internet and how we can access it. Also, it must be written in clear and plain language, no technical jargons. I don't want to hear any technical expressions in these privacy notes. Don't tell me I will make VPN and DLS and LLSSL, and I don't want to hear this. I am a normal user. I am not an IT person. I don't understand what you are saying. This, you are speaking Chinese language for me. Now I want a very clear, plain language. This, it will be very clear for me. And it should be delivered in timely manner. Because when I want to see it, it's not acceptable that, okay, I can provide it to you after 1 or 2 or 3 days. No, it must be immediately. Now, because now any site want to ask me, please enter your information. Then I have to open the site to check how what is their privacy notice. But if they will tell me after 2 or 3 days or whatever, then this, it's not acceptable. And it should be provided free of charge, no charges, no charges. It should be provided free of charge. These are the objectives of the privacy notes. What are the components which you have to see in the privacy notice? Because you are a data subject, you will provide your information for a specific organization, and you want to know what are the components which you want to see in the privacy notice. Number one, identity and contact details of the organization and its representative and the DBO. You want to see the information of the DBO, contact information. Tell me, why you want to see the information of DBO? Why the contact information of DBO must appear in the privacy notice? What do you think?
Is it necessary that privacy notice should be updated each month?
Your voice is broken. Can you repeat what did you say, please?
Is it necessary that privacy notice should be updated?
Okay, but this is not the reason why you want the information of the DBO. Why you need the information of DBO in privacy notice?
So in case of any violation done to the data, he will be accountable?
Yes and no, because as a data subject, if you want to have any information about your data, about your access for data and so on, who is the responsible person in any organization to provide you this access of the information or answer your questions?
The
DBO.
Yeah.
In this case, I must have the contact information for the DBO. Okay. Purpose for the organization to process individual personal data. What is the activities, the personal or the processing activities? Why do you need the my data? What are the activities or the activities processes which you will require my data? You have to make it very clear. I want your data because I want to send you some information, or I want to print invoices, or I want to make analysis for the services provided to the user, and so on. Also, the legitimate interests of the organization. What is the legitimate interests of the organization? Why do we want to collect this data? any recipient or categories of recipients of individual data. This organization controller, he may have a processor. He may have a processor which it will do some data processing on his own. On his behalf. When this means that you must have a copy of this, we have to tell you that the data, it will be maybe shared with other company, and this company, it will be so and so. Also, we must have information if there is any data transfer for your personal data. If the data, it will be transferred within the EU countries, we don't have any restrictions. If the data, it will be transferred to between EU countries, we don't have any data restrictions, data movement restriction. But if the data, it will be transferred to any processor outside EU countries, then this means that we must have a contract and we must have security controls, and we will discuss this in more details. But in the privacy notice, you must know if the data, it will be transferred, and if it will be transferred, where it will be transferred. Is it to a country inside EU or it's not in EU? Okay. Also, we have to have the right that you can withdraw the consent. You must have the right to withdraw the consent. At any time, I want to withdraw the consent. This means that please drop my personal data. You are not allowed to utilize it as a controller because my consent is withdrawn. Also, the right for the right of data subject to lodge any complaint with the supervisory authority. You have a problem, you contact the DBO of the organization, of the controller, but they did not respond on time, or they did not provide you the information you required, or whatever any action you require, then it have to mention that you have the permission that you can lodge a complaint with the supervisory authority. We have to mention also if the personal data, is it a part of contract requirement or any obligation. This means that we have to define what is the legitimate purpose for collecting and processing the data. As we mentioned, we have 6 legitimate purposes. We have to clarify which legitimate process or purpose we are using here. Existing of an automated decision-making system. There are some situations, for example, I am a company provide loans to persons. There are some companies, we are collecting the data and we will process this data automatically to check if the user is capable to receive the loan or not. Then if you have any decision-making system run on automatic based procedure, you have to be very clear of that, because if this is the scenario, the data subject, we have the right to refuse the result of the automated data decision-making system, and we ask to do it manually. In some situation, for example, it may be a non-natural person. He may be a handicapped person, for example. Then if we are a handicapped person, then they have some permissions over the normal natural persons. When you have any decision-making system, automatic decision-making system, you have to make this very clear and to define this very clear in the privacy notice component. Also, you have to define the retention period. What is the retention period for the data? And after the retention period, it will be expired. What you will do with this data? How the data, it will be what we can say, stored or it will be removed from the controller side after the retention period is expired. Just I want to show you some examples of the privacy notice examples, and unfortunately we are not caring about this. But here, for Microsoft side, in the bottom of the screen, you will find here privacy. In Cisco, you will find privacy statement. It can be privacy statement or privacy notice. Let's go and check this live. I will open the internet. Tell me any site. Give me the site name, whatever any site name.
Microsoft.
Usually, if you want to see the privacy, what I am doing, I have to go to the bottom of the screen. You will find it in this area. Here you are. Look here, what are the privacy statement? Personal data we collect. How we use personal data. When this how we use personal data, it will be processing activities. Reasons we share personal data. The legitimate purposes. How to access and control your personal data. You remember when we said in GDPR principles, accuracy, and accuracy part of it that you must have the permission to access it and update it. Cookies and similar technologies. Products provided by your organization, notice to end users. Microsoft account. Collection of data from children. Enterprise and developer product, and so on. Then you will find all the related information to privacy. Let's have another site. Just tell me any other site in your mind.
Amazon.
Where is look here? Here we call it privacy notice, as we call it. In Microsoft, we call it privacy statement. Here we call it privacy notice. It will not make any difference, but by the end of the day, all of them, we are the same. Look here, this Amazon privacy notice. Look, what personal information about customers does Amazon collect? For what purposes does Amazon use your personal information? The personal information here, the activities, personal activities processes, cookies and other identifiers. Does Amazon share your personal information? It can be shared with different processor or shared party, third party. Here, look, transaction involved with third party service providers, business transfer, protection of Amazon and others, and so on. Then these are the information which it will be collected. If you agree about this, that's great. If you don't agree, then this means that you have to write to withdraw your information. Let's take last site. Just again, tell me any other site to have a look on their privacy notes, to be familiar with it.
Facebook.com.
Here it's coming in Arabic. Okay, let's check for privacy.
Right side.
Here,
Yes.
we call it data policy. We don't call it as privacy notice or privacy statement. We call it data policy. It will not make any difference because look again, what kinds of information do we collect? all the sites, they start with the collection, data collection. When we will go to the processes, how do we use this information? When these are the processes. When you will find how the information is shared, third party or processors, then we are almost the same. We are almost the same because now we are speaking about the same concept of GDPR or personal information. Okay? Is it clear?
Yeah, so just a question, Osama.
Sure.
I just wanted to ask, like, how often this policy or this privacy notice is been updated? Like, is it a kind of a time frame that, yearly or half yearly? So how that has been updated?
Okay. Usually, if there is no major changes for anything, then it should be yearly to be reviewed. Yani in management, as security management, usually we are using with major changes or on regularly basis. This regular basis, it will be every year, except if you have a major change. For example, suppose that I am a controller and I am collecting the data and I do the processing myself. But now my business, it's increasing and I have a lot of customers and I'm not able to handle all this process at the same time. Then what I have to do, I have to get a third party data processor. Then this, it's considered a major change. Then I have to update my privacy notice immediately to reflect the changes to my users and customers. But if I don't have any changes, then if it will be reviewed regularly, it will be okay. I mean yearly, it will be okay.
So
Okay,
somehow the privacy or data.
Sorry, your voice is very low. Can you speak loud, please?
Yes. Let's somehow the server, which the DB server has been leaked, then what will happen on that case?
No, this we will speak about it in the last module. We have a module called data breach. We will speak about it in more details. What are the actions, legal actions, and all this stuff. We will speak about this day after tomorrow, inshallah.
Okay, inshallah.
Okay, I think it's 8 o'clock now. Let's have our break for 10 minutes and we will continue. Okay. Thank you for coming back. Today we are in the second session for the GDPR and we discussed some important subjects as the privacy notice, GDPR principles, and the legitimate purposes for personal data collecting and processing. Now we will have a new topic for the personal data inventory. Sometimes we call it personal activities inventory. Personal data inventory or personal activities or process activities inventory. Then what is the personal data inventory? It's the record of all personal identified data housed within an organization, website, or its affiliates. This, whatever any personal data, inventory of personal data record, which is housed by the organization, even it's in the form of a website or affiliates or whatever. You may find another expression we called processing activities inventory, but there will be no difference. Processing activities inventory, it will tell you what are the processes required your personal data and what are the type of this personal data, inventory of this personal data. Or if it's personal data inventory, then it will tell you what are the personal data and what are the processing activities. Then any one of them, personal data inventory or personal process activity process, activities processes inventory, whatever any one of them, it will be the same. Both of them means that the organizations or the controller and the processor must have an inventory for all the data and the processing activities related for this data. Okay. This is the second expression, processing activities inventory. Before we mentioned personal data activity inventory, and here processing activities inventory. The processing activities inventory is inventory of the organization data processing activities. Before it was inventory for personal data. Here inventory for the data processing activities and all the personal data required for these activities. And all the personal data required for these activities. This is a very important tool because this it will help for, to be compliant with GDPR regulation. GDPR requires that you must have inventory for all this information, even it's the personal data or personal processing activities, whatever it is. But they are required by GDPR to be compliant with it. Okay.
I have a doubt here. Like,
yeah, please go ahead.
The previous slide, when you say it is like affiliates, which means like an organization is having its own data center, or it could have its data in the cloud. So is this affiliates mean to the place like where the data is stored outside the organization?
Okay. No, we are speaking here about the affiliates side. By the way, even the cloud, the GDPR, we did not speak about concept of cloud or sharing the data on a cloud or whatever. By the end of the day, if the data it will be processed on the cloud, then this cloud will be considered as a data processor, and you have to make an agreement with him as a third party, a contract with him. And you have to mention what are the security controls required to protect this data and to prevent its leakage.
Yeah, okay. So what is meant by the affiliates here, like specified in the personal
locations?
Data?
For example, when you will say that I have a head office or headquarter in America, and I have other branches distributed all over the world, then these branches, it will be considered as affiliates.
Okay, thank you. Yeah, yeah, okay.
You're welcome. Okay. What are the inventory components? What are the inventory components? First of all, as we mentioned, the activities, processing activities. Then you must have processing activities. For example, I want to print invoice, the activities, it will be printing invoice. Whatever any other processes you have to mention. What are the legitimate purpose of collecting the data? What is the legitimate person? Because as we mentioned, GDPR, we have 6 methods for collecting the data. You have to define what is your legitimate purpose for collecting the personal data. And this activity, who is the owner of this activity? Who is the owner of this activity? What do you think? Suppose that the financial department, we are printing the invoices for the users, as we mentioned in mobile service. Do you think that the financial department is the owner, activity owner, or the DPO is the activity owner?
Financial is the activity owner.
Financial is the activity owner. Okay. Any other opinion? Okay, you are right. The activity owner, it's not the DPO. It should be the department which it will make the process. But again, they have to be reported to the DPO. we have to make sure that with the DPO that all the processes are legal and all the processes are compliant with GDPR and all the privacy for the data subject information is protected and so on. Then the owner, it will be the department or the person who will do the process. But again, we have to be reported to the DPO to make sure that we are compliant with the GDPR rules. Okay.
Okay, so does that mean it goes to the department and then to the DPO?
It will not go to the DPO. It will be reported to the DPO.
Okay, got it.
Okay. Personal data. What is the personal data? It will be processed. My name, my mobile number, my email address, my identification ID, my physical address, whatever any type of personal data. And where this personal data, it will be stored. It may be in CRM, and this CRM, is it hosted on the cloud or it's on-prem? It may be ERP system. Then whatever the system which is utilized this data, it should be highlighted and mentioned in the inventory. Processor. Do we have any processor? If the company, the controller, he have a third party to make processing for the data. Then processor presence. Do we have any processor? If yes, we have, then who is this processor or the third party? Of course, third party, it is a processor, but again, it can be a processor, it can be vendor, it can be customer, whatever the any other third party which it will receive the personal data for any legitimate purpose. Retention period. What is the retention period for the data? The data, it will be stored for 1 year, 2 years, whatever. Do we have any other law which it will override GDPR? For example, in Saudi Arabia, we say that the government states that the data should be available for 1, 2 years. Then now the purpose of the collecting the data for printing invoice or whatever, this it will be the activity, it will be for 1 year. Then after the 1 year, it will be expired. This means that all the data should be deleted. Otherwise, the user, he renew the contract. If he renew the contract, he have to stay 1 more year. But if he did not renew the contract, then this means that the company, they have to remove the data subject personal information because their contract is expired and there is no legitimate purpose to keep this data for the controller. But we have a problem that Saudi Arabia regulations, it's saying, no, you have to keep the data for 2 years for any problems or investigation, then we can refer for this data as a record. And in this case, we have to keep this data for 2 years. In this case, yes, it's allowed for the controller to keep the data 2 years, as mentioned by the country regulations. And of course, we have to type the justification. Why do they kept the data for 2 years instead of 1 year as the contract mentioned? What will happen after the retention period? How the data, it will be destroyed. It will be hard disk destroyed, it will be encrypted, it will be shredded, whatever the type of the data destroying method. Another thing which is very important in the inventory is the data transfer. Do we have any data transfer? Yes, we have. Okay, is it within EU countries? If it's within EU, then no problem. This, it will be allowed because all the countries in EU are subject for GDPR law. Or no, there are some data, it will be transferred outside EU countries. When this means that you must have a contract, signed contract between the controller and the processor or the third party, and this contract should have security controls and safeguards required to protect this data. Okay, any questions? Okay, Also, in the inventory, we must have some additional information. And this inventory, of course, if you are a data controller or a data processor, you must have your own inventory. If you are a data controller or a data processor, you must have your own inventory. Question. Suppose that we have an organization, we are working as data controller and data processor at the same time. It may be data controller for specific activities and data processor for other activities. Then what do you think? How many data inventory should they have? How many data inventory should they have? Any answer?
Maybe one data inventory, but they'll have some regulations to process it from there.
Okay. Any other opinion?
There should be one because one side from controller and one side from processor.
Okay. Third opinion? Okay. They must have two inventories, one as a controller and one as a processor. They must have two. This is a very important question, and sometimes you may find it in the exams. You need two inventory. Okay. In the inventory related to the controller, as we see before, these are the information which we want to see: activities, personal data, processor, retention period, data transfer, plus this additional information. What is the DBO contact information? Processing activities purposes, legitimate purposes, personal data recipient. If there is any third party where you receive the data, if the data, it will be transferred outside EU, retention period, and security safeguards. So they are almost the same which we mentioned before. Also for the data processor, contact person information in the processor side, data protection officer contact information, which is related to the data controller, data transfer outside EU, and what are the processing activities. Almost we are the same when we can summarize it as the slides here. This is a slide which summarizes the activities, personal data collected, processors, presence of processors, retention period, data transfer, and so on. What is the inventory advantages? Why do we want inventory? First of all, as we mentioned, inventory, it is mandatory for GDPR compliance. This is number one. But what are the advantages, additional advantages for the inventory? Number one, it will improve the organization privacy posture. Why? Because this means that the company, they are aware about the personal data which they are collecting, and there is a clear relation between the collected personal data and the processing activities, and the DBO is person is well defined, and all his responsibilities are clear. If we have any data transfer, if we have any data processor, and so on, then this means that you have a professional organization privacy posture. As we had a look on the website, just open it and you will find all the privacy notes. Almost we are the same. They will tell you what are the privacy data it will be collected, what are the processing activities, if there is any data transfer, if there is any third party, and so on. Second advantage, due diligence in case of data breach. I remember yesterday, before yesterday, one of our colleagues here, he mentioned that with due diligence, it will be the exercise which it should be done by the organization to protect the data. And I remembered one of you, I think she was a female, she asked what will happen if the data breach, this will be subject for data fines. We said no, because if they proved the due diligence in a proper way and they did their exercise and the data it was breached from a third party, although we have a contract with him and they defined the security controls and we are doing the auditing on him regularly and so on, but still the data are leaked, when we are not subject for a penalty because we proved the due diligence. When if you are able to prove the due diligence, this means that you will not be subject for any fines. The formal documentation and information for supervisory authority in case of investigation. There is a problem happened, data leakage, and the supervisory authority it start to investigate the case when we ask for the formal information, inventory, and of the data and all this stuff. Then, if it's properly documented and provided to him, then this it will be very helpful for the supervisory authority and for the organization to prove the due diligence and that they are doing the exercise properly. Okay. What are the inventory rules and responsibilities? Number one, the DBO. As we mentioned, DBO, he is not responsible for conducting the data inventory. He is not responsible. Not. Who is responsible for conducting and maintaining?
Data processor.
Sorry?
Data processor.
The process, the department which makes the process, you are right. But as we mentioned, the department or the business unit which it makes the process, they have to be reported to the data protection officer to make sure that this is compliant with the GDPR. What is the role of the DBO in the inventory process? He has to make sure that the inventory exists. Inventory existence. You have to make sure that inventory existence. This is the most important for me. I want to make sure that the inventory existence. Then the DBO, he have to go to each business unit and, hey, you are using personal information. Do you have a record or inventory with the personal data which you collect and the processing activities? Yes, we have. Show it to me. Here you are. Okay, then you are compliant. That's fine. We don't have any problem. The second role, it will be the business unit. This is a business unit which is responsible for conducting the data inventory. And as we mentioned, that we shall be reported to the DBO. And we must have a representative from each business unit, because of course business unit, this it will be maybe some departments may have 1, 2 or 3 persons and some others may be hundreds. Then we must have a representative from each business unit, and he will be reported to the business unit manager and the GDPO at the same time, because he will work very close with GDPO to make sure that we are compliant with the GDPR requirements. Finally, the controller and processor. As we mentioned, if you are a controller and the processor at the same time, then this means that you must have 2 data inventory, one as a data controller and another one as a data processor. Okay.
Understood.
Okay. Any other questions? Okay. Retention period. There is an important point here, my friends, that GDPR does not specify specific retention period. We will not tell you you have to delete the data after 1 year or 2 years or 3 years. No. But what we will ask for, we want the organization to define a specific retention period, which it would be acceptable and matching their business needs, requirements, and the agreement with the data subject. As we mentioned, I have an agreement or contract with the company to provide me mobile service. Okay, great. The contract, it's it will be renewed every year. The contract, it will be renewed every year. That's fine. If the contract, it will be reviewed every year, no problem. But you have to make sure that the data after every year, it will be deleted. available for 2 years, for example, as we highlight in some specific countries, then you have to be very clear with the data subject. You have to write this in your privacy notice that the data, it will be stored in our premises for 2 years, although it's not required, but the regulations of our country state that this data should be available for 1 additional year. This the retention period for the GDPR. Sorry, your voice, it's not clear. Can you repeat what did you say? Okay. This means that you must have a data retention policy. You must have a data retention policy as an organization, controller, or processor. When the retention policy, it will define dates and times and periods. But as we mentioned, this is related to the organization. When one organization defines the data, it will be kept for 5 years. Another organization in another country, it will say it will be for 3 years. Another organization, it will be say it will stay 10 years. Wow, 10 years, why? Because the process which I am doing, it will be manufacturing or whatever, and it will take a long time, and 10 years is the time which is required. Okay, but if the process which you collect the data for and you have the purpose or legitimate purpose for it, then it will be okay. Whatever it is. And this means that you have to define your policy. You have to define your policy as controller or as processor. We have to define the personal data policy. This is very important. And we have to define the retention policy. We have to define the data retention policy, how long the data it will be available, and how the data it will be disposed. How the data it will be disposed when the data it's not be no longer needed. This is very important, my friends. In the exams, they are playing on this information because when you say data retention policy, then immediately what you will come to your mind that okay, you want to define the period. Then I will give the data for 3 years, great. But they will ask you, okay, one of your data subjects, they want to understand how long the data it will stay in their sites. Then you will say, okay, data retention policy, it mentions 3 years. Okay, what will happen with this data after the retention policy it's expired? Okay, the data will be disposed, but how we can know from where? This it should come from the data retention policy. This it should come from data retention policy. Okay, organizations should develop personal data organization policy to help them managing and disposing personal data. This is very important. Then we will be able to understand how we will deal with the personal data and how we will provide the required information to the users when they require. Okay, what are the components of the data retention policy? What is the template? Number one, what are the, or what is the type of personal data? What is the type of personal data? Name, address, email, ID number, mobile number, landline number, whatever the data which it can be collected. What are the legitimate purpose of the data processing? It may be contract performance, consent, whatever. The retention period, and if we have any laws and regulation, it will override the retention period required by the process. Process say that I need the data for 1 year, but I have country regulation which it mentioned that we need the data for 3 years. And also, it's very important to define disposable methods, data disposable methods. Just for your information, what are the available disposable methods for data, my friends? What are the available methods for disposing data?
Ideally, it has. I mean, I was being in the part of one of the investment banks, so they were having a disposal policy, as a part of records management. So what they, I mean, what ideally it happens is, it should have a methodology of disposing your data as to it could be a soft copy or a hard copy. I mean, it depends on what kind of records you maintain in any investment bank. Like I was with the RBS, Royal Bank of Scotland. So that too, at that time it was they were having such kind of disposal methodology, which ideally I came across.
Okay, what are these type of disposing data, digital data?
Wiping the hard disk.
Sorry?
Hard disk wiping.
Okay, hard disk wiping. What else? Okay, let me make it very easy for you. The data disposal, the digital data disposing, there are three popular methods. Destructing the hard disk, physical destruction. I will get the hard disk and I will destruct this hard disk, destroy the hard disk. It will not be accessible anymore. Or I can override the data, which is called override disposable method. And override, usually we are saying it's not safe because even if you override the data, it can be retrieved again. In some standards, where you will say that you have to rewrite the data 2 or 3 times with a specific patterns. In this case, the data, it will be safe. And the last method, it will be data encryption. Last method, it will be data encryption. When you can encrypt the data, and after you encrypt the data, destroy public and private key. Because if you encrypt the data and we destroy the public and private key, then the data, it will not be able to be recovered. These are the popular methods which you can use it in disposing the digital data. And for example, if you are making an agreement with your cloud service provider, one of the very important points which it should become in the service level agreement, how the data will be disposed. Of course, it's nonsense to go to your cloud service provider and tell him you have to destroy your hard disk. You will of course, you will not accept this suggestion, because this means that you will lose money. Then we have to make the override or to encrypt the data. Of course, encryption of the data, it will be the best methods, and especially if you will have the private and public key, and you will be able to destroy these keys, when the data, it will not be recoverable anymore. Okay. Any questions? Now we will go through one other topic in the GDPR, the consent. And this is one of the legitimate purposes for collecting and processing the data under GDPR. And this is the indication of the data subject that we are agree that you are able to collect the data and processing the data for them, or their data, in other words, their data. When this is consent, then you can process the data subject information. GDPR consent conditions. We have some important conditions now. It's not just to have a consent. No, we have conditions for this consent. What are these conditions? If the consent should legitimate the processing of special categories of personal data, information of data subject must expressly refer to it. This means that you must define what is the legitimate purpose for collecting the data. I want to have a process for example, send you the new services and offers in our company. Okay, that's fine. We don't have any problem, but you have to be very clear. please, my customers, we are planning to initiate new services and process, and I want you to do this exercise and provide me your information. Then we will be able to send you our information or our quotations and services. The controller shall be able to demonstrate that the data subject has consented to processing of his or her personal data. And the controller, please don't come and tell me, we ask the data subject and he made the consent. Okay, he makes the consent. How you can prove it? Then if you do it digitally, you must have a backup copy of it. If he do it on a paper, you have to keep the paper. Whatever the methods which you can prove the consent. And if I ask you for the consent, you have to provide me the proof that the data subject provide this consent for the controller. The data consent must be very clear when you will provide data consent for, consent for ask data subject for consent. It must be in a clear language. Don't ask with technical expressions. It must be very plain language, clear and very specific. Don't ask for something which it can be understandable in a different ways. No, I want your personal information to add it to IT certificates distribution list. This is very clear. And even when I say distribution list, someone, he can say, oh no, this is not clear because I did not understand. You mean distribution list on WhatsApp or distribution list on email? Aha, okay, you are right. Then I want to collect your personal information to add you to IT certificates, WhatsApp and email distribution lists. This is the method which it will be accurate for collecting the personal information and have the consent from the user. The data subject, he must have the right to withdraw his consent at any time without affecting the level of the service providing to him. For example, I am a subscriber to the company, which I have an mobile service, and the usually I had OSN subscription. Sometimes I'm receiving a phone call and they asking me, we are providing some new services. Do you agree to receive our quotations and so on? Then I say yes or no, it depends. Then I must have the permission to call them by phone. Please, withdraw this consent. I don't want to receive any information. I don't want to receive any email. By email, it comes spammed, and there are a lot of emails which I don't have the time to read it, and I am not able to reach to my formal emails, which is important for me. Then please, I want you to withdraw this consent when I will not be receive any information from you. Also, after the user or the data subject, he will provide the consent. He must have the access to the data. Then he will be able to update it and keep it up to date. The consent must be binded to a specific purpose. Must be binded to specific purposes, as we mentioned. Don't collect the data for a specific purpose or purposes, and after that you will use it for a different purpose. No, this is based on GDPR conditions. It's illegal. You have to be very clear about the information required for the informed consent and the information about contract matters. For contract matters, it may not be optional. And for any reason, I have a contract with you and I am required some information. This information, it will be mandatory because it's based on the contract performance of contract. But for consent, this means that it's a different issue. It's not related to the contract. When I have to be very clear that this information, it's not affecting the contract at all, and your services, it will be the same, even if you refuse to have this consent. For example, in some situation when they are calling me in OSN, we have new service and this it will cost you so and so. I'm saying, no, I'm really sorry. I am not interested in this service anymore. Then this means that I will still have the same service as I used to have right now. And this it will not affect the performance of the service which I have. Okay. For GDPR consent conditions, we have some conditions. The consent, it must be in very clear statement and clear affirmative act. As we mentioned, we don't want to have jargons. Sorry, I was muted. I don't know what was the problem. Okay, I will repeat this slide from beginning. GDPR consent conditions. We have some conditions for GDPR that the consent must be, it means it requires to be either a statement or clear affirmative act. It should be very clear. It should be very clear. There is no room for misunderstanding or understanding in a different way and so on. This is not acceptable. If you reach to this point, then this concept is not accepted and you are violating GDPR if you are using the data of the data subject. Also, it cannot be implied and must always be given through an opt-in. This means that a declaration or an active motion. This means that there is no misunderstanding. There is no misunderstanding that the data subject has consented to a particular process. In other words, don't say that I give you the consent, but there was misunderstanding and I did not understand what did you mean because it was not clear and all this stuff. When we will come to the point that it was not clear, when the consent is not acceptable. Also, so for these controllers who are collecting the information for children under the age of 16, there will be another condensed authorization requirement from the parent. It's not enough to have a consent from children because we are, by the end of the day, we are children. Then you must have a consent from the parent that you accept that their children's data, it will be processed and collected. Finally, as we mentioned before, consent must be recorded for future reference because today I will go to the supervisory, as a data subject, I will go to supervisory authority and I say this controller, he collected my data without my permission. Then if it was collected with my permission, then we have to get this consent and submit it to the authority and to prove that they collect this data based on my approval. Okay. Any questions?